You know, when you think about Canadian criminal law, it seems incredibly complex. But what if I told you that the entire path of a case, from the moment of arrest all the way to a final appeal, actually hinges on the answer to just one single question?
So what is this magic question? You might think it's something dramatic like, guilty or not guilty, or, who's the real culprit? But nope, it's something way more fundamental, something that happens behind the scenes, but sets the stage for everything to come.
And that's it, right there. What kind of offense is this? It sounds so simple, almost administrative, right? But the answer to this question is everything. It determines the court, the potential penalty, and even what rights the person accused of the crime has. It is, quite literally, the starting point for the whole shebang.
To really get what that question means, you have to understand how Canada sorts its crimes. Every single offense in the criminal code is funneled into one of three categories. Think of them as three totally different roads a case can travel down.
Okay, so what are these three paths? You've got summary conviction offenses, you've got indictable offenses, and then you have this really interesting one called a hybrid offense. We're going to get to that one in a minute, but first, let's break down the two main categories.
So, let's start with summary conviction offenses. These are basically the least serious crimes on the books. You can think of them as being kind of like misdemeanors in the US, things like causing a scene in public. The whole system is really geared to process these cases quickly and efficiently.
And then on the complete other end of the spectrum, you have indictable offenses. These are the big ones, the most serious crimes. They're the equivalent of felonies. We're talking murder, robbery, things like that. And because the stakes are so incredibly high, the whole process is way more detailed, and the accused person gets a lot more procedural protections.
And when you put them side by side, the differences are, well, they're huge. For a summary offense, the Crown only has a year to charge someone, and the max penalty is just under 2 years. But for an indictable offense, there is no time limit to prosecute, ever, and the penalty can be life in prison. Even the court is different. Summary cases stay in provincial court, but the big, indictable cases can go all the way to the superior court, where the accused usually gets to choose if they want a jury.
Okay, but what about all the crimes that fall somewhere in the middle? Well, this is where it gets really fascinating. See, most offenses in Canada's criminal code aren't strictly one or the other. They're what's known as a hybrid, and that puts an incredible amount of power into the hands of a single person.
So a hybrid offense is exactly what it sounds like. It can go either way, and the person who gets to decide is the Crown prosecutor. They look at the specifics of what happened and then make a call. Do we treat this as a less serious summary case or a more serious indictable one? It gives the system a ton of flexibility to make sure the punishment fits the crime.
And you can really see just how massive this choice is when you look at something like assault. Let's say it was a minor scuffle in a bar. The Crown will probably go the summary route. It's faster, it's simpler, and the penalties are lower. But what if that same assault caused a really serious injury? Well, now the Crown can choose to proceed by indictment, which opens the door to way harsher penalties and the possibility of a full jury trial. Same crime, two totally different worlds.
Now here's a super important detail you need to know. Until the Crown prosecutor stands up in court and makes that choice, the law automatically treats every hybrid offense as if it's the more serious, indictable version. And that's a big deal, because it gives the police more power right from the get-go for things like arrest and fingerprinting.
So, once a case is officially on the indictable path, either because it's a super serious crime to begin with, or because the Crown decided to go that way, a whole new set of choices opens up. But this time, the choice belongs to the accused.
Well, usually. The criminal code actually carves out two special categories of indictable offenses where there's no choice at all. You can think of these as the no-choice zones of Canadian criminal law.
So the first zone covers the less serious indictable offenses, like theft under $5,000. For these crimes, the law is absolute. The trial must be in provincial court with a judge, and only a judge. The accused has zero say in the matter.
The second no-choice zone is for the absolute worst of the worst crimes: murder, treason, piracy, and, my personal favorite, just because it's so specific, alarming Her Majesty. These cases are automatically sent to the highest trial court, the Superior Court, to be heard by a judge and a jury. No exceptions.
So, what about all the other indictable offenses that fall in that huge space in between? Well, for those, the accused gets to make a decision that could change their life. It's called their election, and they get to pick one of three options: trial by a provincial court judge, trial by a superior court judge alone, or a trial by a superior court judge and a jury.
You're probably starting to see it now, right? That first decision, that classification of the offense, it's not just some legal technicality. It creates a massive ripple effect that touches every single thing that happens after.
It's true. The type of offense defines the sentencing range, it determines which prison you'd go to, and it even dictates your options for an appeal. It all flows from that one initial choice.
Take prison, for instance. The rule is incredibly simple but stark. If your sentence is under 2 years, you serve it in a provincial jail. If it's 2 years or more, you're going to a federal penitentiary. This 2-year rule is a direct consequence of whether the offense was treated as summary or indictable.
And even when the trial is over, the path splits again. If you're convicted of a summary offense, your first appeal is heard in the Superior Court. But if it was an indictable offense, your appeal goes to the much higher Provincial Court of Appeal, and maybe even all the way to the Supreme Court of Canada, 2 completely separate appeal systems.
So let's just trace that logic one more time so it's crystal clear. First, you classify the offense. That decision then dictates the entire procedure, which court you're in, what kind of trial you get, what rights you have, and finally, that procedure sets the boundaries for the consequences, the penalty, the prison, and the appeal.
And all of this leads to a much bigger, more fundamental question. When you have a system where an entire legal journey is basically set in stone by one decision at the very beginning, a decision sometimes made by just one person, what does that tell you? Is this system built for efficiency above all else? Is it built for fairness? Or is it just a constant, delicate balancing act between the two?